Hello, fourth semester. Today I am here to discuss with you the admissibility of electronic evidence under the Indian Evidence Act. As we all are aware of the fact is that now we can rule the world through the tip of our finger, and that all is possible just because of the invent of the computer. So either it may be CCTV footage or the receipt of an online payment. Electronic records becomes the part and parcel of our life, and it is required that these electronic records must have to be included into the definition of the evidence under the Indian Evidence Act. By the enactment of the Information Technology Act 2000, Indian Evidence Act was amended, and wherever the definition or wherever the word is evidence or the document is mentioned, it has to be amended as like that it includes the electronic records. Either it may be the section 3 where the document has been defined and it included that electronic records, or it may be section 17 where the admission has been mentioned, that the statement either it is oral, documentary, or it is by the sign, or it included the electronic evidence or electronic records. So wherever the word evidence or the document has been used, it included the electronic record. Though the admissibility of the electronic record is ruled by the provision, specifically mentioned provision, that is the section 65A and 65B of the Indian Evidence Act. But before the issue of admissibility, there is a issue of the relevancy comes. And as we all know that the test of relevancy is mentioned from the section 5 to 55 of the Indian Evidence Act. So all these sections from 5 to 55 is applied to the electronic records also, and some specific sections has been added to this Indian Evidence Act through the 2000 amendment, such as like that section 22A, where the genuineness of the document which is in electronic form as admission has been provided. There is section 24, 34, 39, 47A. All these deals with the relevancy of the electronic records. When we come to the admissibility of the electronic record, so what very important aspect or the point is that section amendment or through the Information Technology Act 2000, section 65A and 65B added to the Indian Evidence Act, which deals with the admissibility of the electronic records. As we have already discussed that the section 61 to 65 of the Evidence Act deals with the document and the contents of the document, and these sections didn't include the electronic records here. So this is the clear intention of the legislature, that the legislature wants the specific admissibility of the electronic records under section 65A and 65B, and that is why these section 65A and 65B added to this Evidence Act. The admissibility principle which has been given in the section 65A provides that contents of electronic records may be proved in accordance with the provisions which is mentioned under section 65B. So section 65A simply says that admissibility of the electronic evidence proved before the court of law in accordance to the procedure which is provided under 65B. So section 65 is a very exhaustive section which provides the elaborate procedure for the admissibility of the electronic evidence. If we read that section 65B, the first clause of section 65B says that notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in an optical or magnetic media produced by a computer, hereinafter referred to as a computer output, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question and shall be admissible in any proceeding without further proof of production of the original. In simple words, section 65 clause B says about that admissibility of the electronic records, and the electronic records which are mentioned in this section is included that every computer output has to be treated as original if the procedure which is mentioned in clause 2, 3 or 4 fulfilled under this section 65B. It means if a computer output produced before the court as an electronic record under section 65 clause B, 65B clause 1, it has to be treated as original, means that original source of that document is not required to prove before the court of law. And if the conditions which are mentioned in section 65B clause 2, 3 and 4, then it has to be taken as a original document. What it means? It means that there must be a computer output. Second thing, it is produced before the court as an electronic record. So section 65B provides that computer output, because it's saying about the computer output, and computer output included everything. Everything means that either it is in a form of the CD, it may be either from pen drive, it may be any other, is a simple document which is produced from that computer or other thing. So all these things, if the conditions which is mentioned in section 65B, and what are that conditions? First thing is that the computer from which the record is generated was regularly used to store or process information in respect of activity regularly carried by a person having lawful control over a period. Second point, that information was fed in computer in ordinary course of the activities of the person having lawful control over the computer. Third thing, the computer was operating properly, and if not, was not such to as affect the accuracy of the electronic record. And the fourth one is that information reproduced is such as is fed into computer into the ordinary course of the activity. 3 or 4 thing is important. Computer, the things or the electronic records is generated by the computer which is used in regular and in the possession of the person who is authorized to take it or authorized to keep it. Second thing is that that document or that record has been prepared in ordinary course of the nature. Third thing is the computer is technically in the sound position that the accuracy of the document or the record is not affected. And the fourth one is that this information has been generated in the ordinary course of the activity from that computer. So this is what, if electronic record produced by the computer in such manner, then it has to be treated as a original document for the purpose to prove before the court of law. It means that if a CD, if a pen drive has been produced before the court as a electronic data or electronic record, then it is not required that the original desktop or the original from the computer in which that CD or through which that CD or the pen drive records which is saved in the pen drive is prepared is required to produce before the court. Second thing which is very important for sake of this admissibility of electronic evidence is that, or it is mentioned in the section 65B clause 4 sorry, which provides that authentication of the electronic record is necessary, or the procedure of authentication of the electronic record. Clause 4 of the section 65B requires for a certificate of authenticity of the electronic evidence signed by a person occupy a reasonable official position in relation to the operation of the relevant device or to the management of the relevant activities. And this authentication is a authentication of the identification of the electronic record or the person who is making that a statement and describing the manner in which it was produced, giving a particular of the device and dealing with any other matter which is required. It means that a person who is authorized to give the certificate must have to be authenticate the identity of the person who is making a statement or other thing or preparing such document or the record or whatever said in that record, whatever record is concerned with the fact, what facts must have to be authenticate by the person who is authorized to do that, and that is the very important aspect of the admissibility of the electronic evidence. So in simple words we can say is that electronic evidence or electronic evidences or the records are admissible in accordance to the provisions which has been given in section 65b, and section 65b says it that all the such evidences which are in the form of the electronic records are admissible if it provides as the procedure which is mentioned in section 65b clause 2 and clause 4. Clause 2 and clause 4 says about that how it is prepared and certificate of authenticity which has been issued under section 65 clause b by the person who authorized it. But now when it comes to the judicial interpretation, there is a very much various opinion in the court or of the court actually from the 2003 judgment which has been given in the State versus Muhammad Afzal case, which was very famous case on the admissibility of the electronic evidence in India. And in this case, it was contended whether the computer printouts for the various telephone records details stood proved as under section 65b. And the Supreme Court held that compliance of section 65b clause 1 and clause 2 is sufficient to prove the electronic record and it can be admissible. It means that in this case, it is not mentioned that the clause 4 means authentication is required. It says that if electronic record fulfills the condition of section 65a, section 65b clause 1 and 2, then it is admissible, and the oral evidence under section 65 clause b, that is not the 65b but the 65d, where that the secondary evidence produced. Section 65 clause d of the Indian evidence deals with that when the contents of the document has to be proved by the oral evidence or the statement by a person who present there when that document has been prepared. So here it said that in case of electronic records, if the section 65b clause 1 and 2 fulfills and if the oral statement given in the favor of that electronic record, then the clause 4 of section 65b is not mandatory. It has to be treated as admissible. Second, in 2005, another Supreme Court decision in the case of State NCT Delhi versus Navjot Sandhu. Admissibility of the mobile call records were questioned again, and contentions on behalf of the accused made by the on behalf of the accused made that reliance cannot be placed on the call records in absence of certificate of authentication under section 65 B clause 4 of the Evidence Act, and this rejection or this contention was rejected by the Supreme Court, and the court again it said that if the electronic record which has been produced before the court is acquainted with the functioning of the computer during the relevant time and the manner in which the printouts of the call records were taken, then it is sufficient to admissible, and the clause 4 requirement is not the mandatory. So up to the 2005 or from the 2000 to the 2014, it was treated, means electronic record was treated as a secondary evidence under section 65 of the Indian Evidence Act, and it is mentioned that if that electronic record under section 65B clause 1 or 2 fulfills conditions of 1 or 2 fulfills, it is admissible. But in 2014, the whole scenario has been changed, and in the case which is named as the Anwar PV versus PK Bashir, Supreme Court 2014 10 SCC 473. In this case, the court overruled that Sandhu case and also the Afzal case, and it provides that a precondition for the admissibility of the electronic record is the certificate of authentication under section 65B clause 4. The admissibility of the electronic record was entertained in this case in detail, and the court held that reading of the section 65A with the section 59 and 63 and 65 of the Evidence Act, it provides that, or it come to the conclusion that section 65A and 65B is a special law which is added to the Indian Evidence Act, and the general law which has been given in section 61 to 65 of the Indian Evidence Act is overruled by this special law. And it means that this is supported, and this whatever I have told it, that the section 60A, 65A and 65B is a special law. This contention is supported by the expression which is mentioned in the section 65B, that it started from the notwithstanding anything contained in this act. It means that it has to be treated as non-obstacle clause, and that is why it says that section 65B supersedes the things which has been mentioned in section 61 to 65, and the conclusion is that electronic evidence now can be only admissible in the case when the requirement of section 65B clause 4 is fulfilled. Means that without the authentication of the electronic record by the person who is authorized to do it, that cannot be taken as admissible. So the whole scenario has been changed from the 2014. But in 2018, again that Shafi Muhammad versus State of Himachal Pradesh, the Supreme Court held that a party who is not in possession of device from which the document is produced cannot be required to produce certificate under section 65B. Further, it was held by the Supreme Court that if an electronic record is used as a primary evidence, the same is admissible in evidence without the compliance of the section 65B of the Evidence Act. This is all about that admissibility of the electronic evidence. But one very important aspect, or the aspect of this electronic evidence, is that which is declared by the Supreme Court is in the case that is Amitabh Bakshi versus Ina Bakshi, the case which is related to the acceptance of the video conferencing, means the taking a witness on the video conferencing, and the guidelines which has been given in this case is very important. So you people go through your books in which the decision has been given and the guidelines for the video conferencing has been provided. And in one more case which is decided in the 2017, in which it is mentioned that if the electronic record is in the primary evidence, the same is admissible in evidence without the compliance of the section 65B, that is especially deals with the tape recorded conversation, and tape recorded conversation in the case AIR 2017 Supreme Court 3228. So this is all about that, the admissibility of the electronic evidence. Thank you, and hope you all are staying at your home safely. Thank you.